Good afternoon, ladies and gentlemen. My name is Mickey. I am your host of Beyond Page One podcast. Today's guest is Paul McGivern. Paul has been a partner at Pacific Medical Law. He is a partner, with over 35 years of experience. He began his medical malpractice defense counsel for 17 years before transitioning into exclusively represent the plaintiff side. Paul is very well decorated and has a ton of awards. We'll go through all of them later. Welcome, Paul. Can you tell our listeners a little bit about your journey into specializing within the medical malpractice space?
All right. I hope you can hear me properly. The journey to where I am right now really started when I was a kid, honestly, because my parents they're both from Ireland, and they emigrated to Canada in the late 40s. And so I grew up in a typical Irish Catholic family. I've got 6 siblings, 3 brothers and 3 sisters. And all of us grew up with an expectation that we would be professionals of one sort or another. Accountants, doctors, lawyers, whatever. And my dad is a physician, or was a physician. And I was always kind of attracted to that as a possibility. And one of the reasons that I was really interested in it was that my dad kept talking about in his career, for him, he said, if you can find a career like he did that still interests you 20, 30, or 40 years in, where you're still challenged, you're still learning stuff, you're still engaged in what you're doing, then you found the right career. And I always thought that medicine could be that for me. For a variety of reasons, medicine just sort of never really worked out for me. And at the time when I was looking around for what else I could do, my older sister was in law school and she liked it. And I thought, okay, we'll give that a shot. And when I got in, I thought, man, this is fantastic. I mean, I just, sort of died and gone to heaven kind of reaction to it. It was just a really good move for me. And so, I decided, okay, this is what I want to do. And when I finished law school, I was kind of attracted to the possibility or any opportunity that I could get for doing what I call high stakes litigation. And for the first 5 years of my practice, I was doing corporate commercial litigation that was, quite frankly, way over my head. I was working with a guy who was one of the leading corporate commercial barristers in the province. He was so busy that he didn't have time to do a lot of the work that we were doing. So he would just give it to me and say, here, do this, take care of this, take care of that. And it just sort of gave me an opportunity to learn an enormous amount about litigation in general and, high stakes litigation in particular. And I was happy doing that. The problem was that the firm that I was with, I wasn't particularly keen about. So after 5 years, I decided if I was going to make a move, I needed to make it sooner rather than later because I was going to price myself out of the market. And I was lucky enough to get into the firm that was doing the medical malpractice defense work at that time. And the guy who was the head of the group, he knew my dad, he liked me. And so I really wanted to get into the group. And he said, nah, can't do it. It's a closed group. You can't get in. But he said, just keep your mouth shut, keep your head down, and I'll feed you the work. And he just kept feeding me more and more and more. And I kept doing more and more and more high stakes stuff. And then 5 years after I arrived, he was appointed to the bench and he just came into my office and said, here, now this is your practice. And just overnight, I went from being the junior to being the senior, and I was doing the best files, the most complex, difficult files in the office. And things just kind of took off from there. I mean, it was, in other words, I was incredibly lucky. I had people looking out for me. I had, great opportunities just given to me. And I went from there.
That's fantastic. Sometimes luck has a lot to do with it.
Sorry, I didn't hear that. It's a little hard.
I said sometimes luck has something
absolutely.
Something to do with
it. I've been incredibly lucky just in terms of the people that I met, the people that, decided that I was someone that, should be given opportunities. So they gave me those opportunities. And I was incredibly lucky in terms of the just being in the right place at the right time to take over the right work that gave me an opportunity to do what I'm reasonably good at. And if I had landed somewhere else and been doing other kinds of work, I doubt very much that I would have had the success that I have had. So yeah, good luck, good luck and surrounding myself with people who have, helped me out, given me opportunities. Those are the two critical things in my career. Absolutely.
That's fantastic. You made a significant transition from defense counsel to representing the plaintiff side, right? What was the catalyst for that change in your career path?
The primary catalyst was that I'd been doing the defense work for about 17 years, and quite frankly, I was getting bored. Your task when you're a defense counsel is you got to shoot holes in the case that has been presented by plaintiff's counsel, and I was pretty good at that. But I found myself increasingly becoming distant from the people that I was acting for, and the cases all just became, oh, this is a strip case, or this is a hematoma case, or this is a whatever kind of medical problem case it was, and I just decided I need to do something different. I need a new challenge. I need a new focus in what I'm doing. So I just decided I'm going to make that switch. And it was a tough decision to make because there's a lot of financial risk associated with going from the defense to the plaintiff side.
Mm-hmm.
You have to go from an established practice to basically starting over and building a practice. And at the time, I had 3 young daughters at home, and I just decided, I need to do it. So I did it, but it wasn't an easy decision to make. But I just decided I need to do this if I'm going to survive. So I did.
Good for you. Throughout your career, I'm sure that you have seen some very challenging cases and encountered them. How did you navigate these challenging cases?
Well, there's a number of ways that I adapted to the new challenges. And one is I did what I had done when I was defense counsel, which is to surround myself with really, really good, really bright, really incredible lawyers who worked with me through the cases as I was doing them. And I worked with a group of people that were that had the same philosophy as me, which is we need to, rather than doing these things as individuals and just, I have my files and my partner, for example, Suzanne Rabb, she has her files, and my other partner, Lindsay McGivern, has her files. We all work on all of our files together. So it became a collaborative effort. And we're very different from a lot of law firms. We don't have billing targets. We don't have billable hour targets. We don't do anything on a billable hour basis. We do everything on a contingency basis. So we had to work together to make sure that what we were doing was in furtherance of making the firm as a whole successful. And so we adopted what I refer to as the Borg mind. Everything is a hive mind. Every issue that comes up, every case that we do, we talk about it, we break it down, we analyze it, we reconstruct it as a team so that we can put forward the best kind of case that we can put forward on behalf of our clients. And that's really the critical part for me, is making sure that we are acting together, working in unison and moving together, and that we're not competing with each other for, billable hours or, being the best biller in the firm or any kind of that garbage. We're just interested in doing everything as a team.
That's a fantastic way to look at it. I love that.
Yeah.
What are some, can you share with our listeners and with me some cases that have stood out to you, or, have always played a major role in what you do? Anything significant? I'm sure there are hundreds, but.
Well, yeah, sure. Let me answer that in 2 parts. Okay.
Sure.
The first part is the what I call the systemic problem of doing these kinds of cases part. And in Canada, which is where I practice, all of the physicians, for example, 97%, 98% of the physicians in the country belong to the same defense group. They don't have separate insurance. They all belong to this organization called the Canadian Medical Protective Association, or the CMPA. They all throw money into that pot, and they all work together to defend claims that are being brought, against one of their members. So when you're acting for an individual plaintiff, more often than not, we're acting for just regular, in fact, always we're acting for what I call regular people who are or who find themselves in really difficult circumstances, they don't have the financial resources because they are up against, um, uh, you know, defense firms that have, or defense organizations that have billions of dollars, literally billions of dollars, to defend these cases. And we need to be able to put the claims together so that we can overcome those. And so our philosophy is the same philosophy that I had when I was defense counsel, which is you have to basically ignore the cost of putting the claims together, which is not an insignificant task, because in the cases that we do, for example, typically there's somewhere between 10 and 20 expert reports that we have to send to the other side to prove our case. All of those reports cost us somewhere on average between $10,000 and $20,000. So to get to the point where we're going to trial, like we're just outside the courtroom door, it's going to cost us somewhere between $150,000 and $250,000 just in terms of upfront money to put the case together. And then if we go through trial, it's going to cost us another 100 anyway to put the claim together. Now, all of that's money that we are putting up because our clients universally don't have the funds to do that themselves. If we lose the case, all of that money is lost because our clients have virtually no prospect of repaying us, and we don't even try. So that's, if you're looking for reasons to lay awake at night and wonder about, whether we've made the right decision in doing this job, that's one of the fundamental things that, sort of preys on us all the time. It's a systemic problem. In other words, it's not individual to the case. It's a systemic thing that all plaintiffs' counsel have to deal with. And the lawyers that we're up against are extremely good lawyers. They're good people and they're good lawyers. They do these kinds of cases all the time, and they are, their marching orders are defend the case with whatever it takes. So that's what they do. So that's another part of the systemic problem. So all of those things go together to make this practice difficult, make it challenging. In order for us to survive financially in this environment, we have restricted our practice because we're a small firm. There's only 5 lawyers in the firm. We've restricted our practice to doing just catastrophic injury cases. And so, we're always dealing with people who find themselves in very, very, very difficult circumstances. And when you listen to the stories of what they've gone through, it's heartrending. I mean, it's really difficult. And at the end of the day, there's no happy ending. I mean, our clients are still going to be catastrophically injured. All we can do is provide them with the funds so that they can get their lives back together. I mean, we do a lot of what I call birth injury cases. Typically, when they come to us, one of the parents has had to quit their job in order to stay home with the child. The marriages are often under stress because of all the stress associated with taking care of the child. And our task is to provide the family with the funds so that they can go out and hire caregivers so that the parents can go back to work. They can get some normalcy back into their lives. And that's what we're talking about. And sometimes it works and sometimes it doesn't. If you're talking about individual cases that sort of make me wonder sometimes about, this is just wrong. I was involved in a case once where a young woman, she was in her early 30s. She had, as a result of the medical treatment that she received, she wound up, long story short, she wound up being a paraplegic. And, she had to take care of her kids as a paraplegic and blah, blah, blah. And I was acting for the physician who treated her. She had also sued the hospital, the nurses, for what happened. And the plaintiff's lawyer focused entirely on my client, on the neurosurgeon. And my client, for my money, had nothing to do with the problem. The problem was the nursing staff just didn't do their job, and they didn't notify my guy in time that there was a problem. And had they notified him on time, then the problem could have been avoided. As we were getting close to trial, I sent the plaintiff's counsel my expert reports, in which it was clearly outlined my client did nothing wrong. He did everything that he was supposed to do. And the plaintiff's counsel went, okay, and quit. Just dropped the lawsuit entirely. And to my mind, I was thinking, are you out of your mind? I mean, you have a client who's paraplegic. She needs help. And the lawyer just didn't realize that there was a claim there against the nursing staff that should have been pursued. And had it been pursued, it almost certainly would have succeeded had it been presented properly. And yet that was the end of it. They just walked away from it. And even though I was on the quote unquote winning side in that case, in the sense that they dropped the case against my client, I did my job. I thought that that's a good example of a circumstance where the plaintiff's lawyer just didn't do her job.
Yeah.
She had a client who needed her help, and it wasn't there, and that bothered me. I must say that bothered me. I mean, I thought this is a real tragedy because it shouldn't have happened.
That does sound like a massive tragedy. Any other cases that you want to share?
Well, I mean, all of my cases are tough cases. We're just trying now to wrap up a case, for example, where sorry, I should preface this by saying I could go on all day talking about my cases. My wife gets really annoyed with me because she tells me, you never have any happy stories. You only tell catastrophic tales. But, I'll tell you one more catastrophic tale. We've gone through half the trial essentially, and we've managed to establish liability. But the background to this case is that our client is a young mom, first pregnancy. She goes into hospital to deliver her baby, and normally when the baby is delivered, the baby starts head down and moves through the birth canal, and it turns as it goes through the birth canal, and then it's delivered. And this baby, it turns slightly the wrong way, and rather than coming down the birth canal, it kind of turns sideways. And so no matter what the mom did in terms of contractions, this baby wasn't coming out.
Yeah.
And they allowed her to continue pushing and pushing and pushing for 2-3 hours. And then they decided they'd do a cesarean section. But by that time, the baby was so jammed into the uterus that when the surgeon went to deliver the baby, she put her hand in and she pulled the baby out. And in the process, the baby suffered 3 skull fractures with a massive brain bleed, with the result that the baby had permanent brain injury.
Oh my.
That's the kind of case that we do. I mean, those are the kinds of things that's why I say there's no happy ending. These are all cases where when we do our job, we provide the family with the resources that they can use to make their lives better, but they still have the underlying medical catastrophe that they have to live with.
Yeah, that does not go away. Wow. Well, thank you for sharing those. Moving on, you've received a numerous amount of accolades for your work. Out of all those accolades, which of those hold the most significance to you, and why?
There's 2.
Okay.
I mean, I get emails and phone calls all the time from this organization, that organization, saying, we'd like to, name you the medical malpractice lawyer of the year or the month or whatever. And 99% of the time I ignore those because they always come with a caveat. All you have to do is pay us this amount of money and we will, give you the designation, which I say, no thanks, goodbye. Because you're not really earning anything there. You're paying for a designation.
You're buying it.
Don't find appropriate. But the 2 that I find out that are meaningful to me, have meant a lot to me in my career, are, first of all, the designation of KC, which means King's Counsel. And under the legislation in this jurisdiction, only 6% of the lawyers in the province can get that designation. And it's designed to, or historically, it has been a designation of, these are the preeminent lawyers in the province for a variety of different reasons. And that's largely carried through to the present day. So that means a lot to me. Being designated as a KC means a lot to me. And the other the other award that means a lot to me is the Best Lawyers designation. You can see the plaques on the wall behind me. The way that the Best Lawyers designation works is that they send surveys out to lawyers in your own area of practice, being personal injury or medical malpractice or corporate securities or whatever kind of law you do, family law. And they ask the lawyers, who are the best practitioners in that area, in your jurisdiction, in that field of practice in your area. And people vote. And so the designation, the best lawyers, I've been in the best lawyers book since 2006. And I've had 5 Lawyer of the Year awards. Those are the things that mean a lot to me, because those are the things that mean my peers are recognizing me as one of the best in what I do. And for obvious reasons, I find that satisfying.
That's awesome. Congratulations.
Thank you.
I'm sure it's a fantastic feeling. You've had 35 years of experience in the medical malpractice space. How have you seen the field of medical malpractice litigation evolve?
It's evolved in a number of ways. First of all, both in terms of the medicine and in terms of the law. And let me talk about the medicine first. The medicine has evolved to become much more complex, much more difficult, much more sophisticated than it used to be when I first started doing this work. And that evolution has largely been driven by the profession, and I'm talking now about the medical profession, working hard to try and deal with people like me. Doctors don't like being sued. It's one of the things that drives them crazy. And so there are standards that are being published that, to my mind, are clearly litigation based. In other words, they're designed to protect the physicians from attack from people like me just because something has gone wrong. Also, the medicine has become much more focused on developing other potential explanations for things that have gone wrong. For example, genetic testing is now becoming much more common because of some suggestion that a lot of the injuries that are seen after birth are not the result of anything that went wrong during the birth process, but rather as a result of some genetic abnormality in the child. We don't see that as being actually correct most of the time, but occasionally it is true. So that's one of another area where the medicine has become much more complicated, much more sophisticated, much more difficult to deal with. So we have to stay on top of the medicine on an ongoing basis in order to be able to do our job. The other thing that has made how the law has evolved so that this job is much more difficult is that, for example, when I started doing this work as defense counsel, if we wanted to raise causation as a defense, in other words, if we wanted to say, yeah, we might have screwed up, but the screw up didn't actually cause your injury. Your injury was caused by something else. We actually had to get special permission from the CMPA before we could raise that, because it was considered at that time unseemly for us to be saying, yeah, we screwed up, but it didn't really cause any injury. Now, causation is an issue in every single case we do. I mean, we cannot get away from causation as an issue. And some of the causation defenses that are raised are spurious. Some of them are legitimate and very difficult. So we have to anticipate the causation defenses, and we have to be prepared to deal with them as we go through the cases. So it's the medicine and the law is always evolving, and so we, on an ongoing basis, we go to medical conferences, we go to legal conferences, we review the law on an ongoing basis so that we're always on top of it. We have to be prepared for everything that the defense throws at us. So, continuing education is a big deal for us. Let's put it that way.
Yeah. Awesome. What advice would you give to young lawyers aspiring to make a mark in the medical malpractice litigation?
Number one advice, don't do it alone. If you have never done cases like this before, you should absolutely contact someone who has been in the field, someone who has some experience in the field, to work with them so that you try to avoid some of the landmines that the defense can throw in front of you. When I was defense counsel, people who had never done cases before not always, but more often than not, they were just fodder for us to, to pad our stats on. I mean, there was all sorts of things that we could do, all sorts of problems we could create for plaintiff's counsel if they didn't really know what we were doing. They weren't experienced enough to know what we were doing. And so, to my mind, if a young lawyer is looking to do some of this work, as I said, having worked with a lot of young lawyers over the years, I think that there is a minimum 10-year learning curve to getting good at doing this, just because of the amount of medicine and the amount of law that you have to assimilate so you can appreciate the nuances of it. And the other thing is that a lot of young lawyers, they're not as well financed often as more senior people. And there is a tendency to skimp on the expenses associated with putting the claims together. And I highlighted before how expensive these things can be. And I've seen lots of young lawyers that don't want to spend more money on more experts just to, because of the possibility that the defense is going to throw something at them. So they don't. And that often turns out badly because they wind up not dealing with a potential issue that they should have dealt with earlier on. So, it's really important from my perspective for young lawyers to reach out, talk to someone, work with someone who's got some experience in the field, because otherwise you're walking through a minefield and you may not know what you're dealing with at all.
That's really good advice. You've led your practice to be quite prominent. Can you share some strategies that contributed to the growth and success of your firm?
Yeah. First thing to understand is that all the accolades that I've received over the years, they're never because I didn't get them because I'm a great guy. I got them because I surrounded myself with really great people. And I relied on those people to help me, to guide me, to assist me, to do the job on the highest possible levels. I talked about the fact that in this firm, we all work together, and that has led to an enormous amount of success for us. The other thing is that in doing this specific work, there's all sorts of services out there that we get sent our way all the time. Send us your medical records and we'll summarize them for you and we'll tell you what's in them. We never use those services, ever. And the reason that we don't is that if we're going to succeed in these cases, we have to go through the records ourselves, line by line. We have to know what's in them. We have to know what, not only because we need to know what happened on a minute-by-minute basis, but we also need to have an appreciation for what's not in the records or what's only hinted at in the records. And if you have another person summarizing the records for you, or just putting together a brief of what's in the records, you can miss those little details that often should, if we're doing the job properly, lead to inquiries about, well, what is this? Why is this here? What does it mean? What's it all about? And so we never ever use those services. It's a bit tedious from time to time for us to do that line by line analysis, but that's what we need to do, and so that's what we do it. The other thing that we do is when we retain experts to review a case and to provide us with advice on, is this a case or not? We need, before we talk to the experts after they've reviewed it, we need to review the medical literature ourselves so that we can be critical of the information that our experts are giving us. And if they say, in my view, this is this and this, then even if it's supportive for us, we will often cross-examine them on, okay, well, what about this? And what about that? And what about the other? Because even if they're supportive, I want to know how they're going to stand up to what the defense is going to throw at them. And if they're not supportive, it may be that what we need to do is we need to find out from them, well, you've told us that this isn't a problem, but look at X, Y, and Z. To my mind, those are problems. And quite frankly, more often than not, once we put their feet to the fire, a lot of our experts will say, yeah, you know what? I didn't think about that. Let me come back to you. Let me look at that more carefully. So the point is that we need to be critical of what our experts are telling us. We need to be fully versed in the medicine so that we can do that properly. And we need to analyze the cases with our experts with a full understanding of every possible parameter so that we can put the cases together. And finally, just come back to a point I've already made. If you're going to succeed in this thing, you got to be prepared to accept significant risk. There's a lot of risk associated with this practice.
Yeah, no kidding. It seems that you've obviously have grown professionally through the work that you're doing. It's quite challenging. Personally, can you talk about, the growth that you've had by working through this challenging field? Because I'm sure going home every single day after hearing these stories can't be easy.
That's true. Although I find, at least for me personally, in order to survive in this job, you have to detach yourself somewhat from the emotions of what's going on. My wife, every so often, she'll kind of poke at me and she'll say, "I remember when you had feelings." And, that's a function of the fact that as I've gone through this career, you do learn to detach yourself emotionally from what's happened. And she finds that I don't react emotionally to a lot of things, for example, that she would react to emotionally. But that's because I'm used to not reacting. Because quite frankly, if I do react emotionally to the stories that we have to deal with on a day-to-day basis, I couldn't do the job. I couldn't maintain the objectivity that I need to maintain in order to properly analyze what are the strengths and the weaknesses of our case, what are the strengths and the weaknesses of the defense case, and to come to some formula for a resolution of the case. In other words, a potential settlement that will work for our clients and will work for the defense.
Yeah, I find the psyche of lawyers that specialize in very difficult fields so interesting. There could be a whole movie made on it.
Well, yeah, as I said, it is something you learn to do over time.
Yeah.
And if you're going to survive doing this job in particular, and I know a lot of lawyers who just look at me sideways and go, "How could you possibly do those kinds of cases day in and day out?" Only possible if you do detach yourself emotionally from what's going on. You got to be intellectually engaged fully, but emotionally detached. That carries over a little bit, but I try to make sure I don't bring that detachment home, notwithstanding the way my wife bugs me about not having any feelings anymore.
Fair enough. You're involved in the Cerebral Palsy Association of BC.
Somewhat. Well, we were involved before, and now we're involved with other associations since then. So.
Okay. Well, can you speak to the importance of community service in your professional life?
Yeah. I think that we have an obligation as professionals, because we have access to, more funds than a lot of people have access to. We have access to people in power in many respects. We have access to all sorts of resources that people don't even realize are there often. And so to the extent that we can contribute to the community, I think that it's our obligation to do that. And like I said, that we have moved away from the Cerebral Palsy Association just because there are other things that we wanted to do. And one of the things that my wife and I moved to, and that makes a big impression on us, is we think that education is a big deal to help people help themselves, right? And a number of years, just to give you the backstory here, a number of years ago, I came home with a paycheck, and appreciate I don't get monthly paychecks or biweekly paychecks or anything like that. I get paid maybe once or twice a year, if depending on how well things are going. So I came home with a paycheck, and it was a reasonably large amount of money. And my wife and I sat down over dinner to decide, what are we going to do with this? And over dinner, we decided we have enough money for our retirement, so we don't need to worry about that. We have enough money to leave something to our kids, so we don't need to worry about that. So what are we going to do with this money? And so it was an easy decision. Okay, at that point, let's talk about giving back to the community. And my wife had spent years before she retired working in the nonprofit sector. And so she has a particular affinity for ground roots organizations that will, for her money, give you much more bang for your buck in terms of what you can do with the money that you provide.
Mm-hmm.
So she started hunting around, and we wound up connecting with and basically partnering with the Big Sisters organization of the Lower Mainland. And the Big Sisters, you may or may not know, they provide mentors to girls that are potentially at risk, et cetera, et cetera. And at the time that we came to them, they had just lost a scholarship program I think the CIBC had been providing. And the CIBC, provided a like $1,000 or $2,000 a year scholarship to these kids. And my wife and I looked at that and I thought, we can help with the loss of that, but neither one of us wanted to mirror it. In other words, we didn't want to do the same thing, because if you provide a kid who wants a university education with enough money to maybe go for 1 year, all you're doing is providing them with a taste of what life could have been like. Then you're taking it away when the scholarship ends. So we decided that we'd initiate this program in which we will provide for the full undergrad program. So
Wow.
if they want to get an arts degree or a science degree or whatever kind of degree, we will pay the fees for whatever program they want to go into. And in order to get buy-in from the kids, they're expected to provide their own board, their own beer, and their own books. And so it's a partnership so that, they have buy-in and we can help them out. And we think it's a great program. That's the sort of thing that's meaningful for us, and that we think can make a big difference in the community down the road, because to our mind, education is the ticket out of some very, very, very difficult circumstances for a lot of these kids.
That's a fantastic initiative that you and your wife started. Congratulations.
Thank you.
Awesome. In what ways do you believe legal professionals can leverage their expertise for greater social impact?
Well, kind of what I've just been talking about. I mean, we need to beneficiaries. I mean, the lawyers are beneficiaries of, as I said, higher incomes often than people in sort of so-called ordinary jobs. They have a higher social status. They get personal accolades, and because of that, because of their standing, they have a larger voice potentially in the community, and if they get involved, they can have a real effect. And engaging in the kind of initiatives that I've just been describing, I think is important. I'm not a big fan of professionals who acquire enormous wealth and then just sit on it and don't do anything with it. I mean, I think that it's important for us to give back to the communities, because ultimately it's the community that we live in that is providing us with the support for what we do. And we are where we are usually because of the sacrifices of a lot of other people surrounding us, starting with our parents and working through. So, I'm a big believer in giving back to the community in any way we can.
Awesome. With your extensive experience, what are some common misconceptions about medical malpractice litigation that you've encountered?
Okay. There's a number of misconceptions. The first is from a lay perspective. There's a number of misconceptions. One is, if something goes wrong, that means the doctor screwed up and the doctor has to pay. And that is absolutely wrong. The courts have made clear that just because something goes wrong does not mean the doctor did anything wrong. It does not mean that you're entitled to any compensation. You're only entitled to compensation if the doctor essentially screwed up and you got injured as a result of that. So, we have had over the years lots and lots and lots of people come to us with a complaint that this happened to me and the doctor made this mistake, and because of that mistake, I suffered this horrible injury. And sometimes the injuries are significant. Sometimes people are paraplegic, they're quadriplegic, people die because of physician errors. It doesn't mean that there's a right to compensation. I mean, when I was defense counsel, one of the primary defenses was, if I can say this, shit happens. Bad things happen to good people, and it's a fact of life. The only way that people are entitled to compensation is if we can prove that the doctor fell below the standard expected of a reasonably competent physician and that fall resulted in injury to the patient. So that's the first common misconception. The next common misconception, and people in the this is largely in the legal community, but it filters out into the community at large, because people go to lawyers and they say, this terrible thing happened to me, I want to sue, and the response they get, and we have people come to us all the time saying, I went to see a lawyer and the lawyer told me you can never sue a doctor. The lawyer, and that's just wrong. I mean, if that were wrong, or if that were correct, my children would have starved to death a long time ago. I mean, there's a particular way, there's particular avenues in which compensation can be obtained, but you need to know the job. You need to know how to do it. The other thing that I think is important for people in the public to understand is that when we are retained by an injured party, we're not going to be pit bulls. We're not there to prove that the doctors or the nurses or the midwives or whatever are terrible people and that they should be punished. By and large, a vast majority of physicians, nurses, other medical professionals are really good people doing really good work in often really difficult circumstances. It's just that sometimes things go wrong. I mean, there is one of the judges of the Court of Appeal here in BC said years ago that the simple fact is that everybody screws up. Everybody screws up. And most of the time, nothing comes of it because, for a variety of reasons, but occasionally when you screw up, somebody's injured. And that's why people have insurance. And our task, our job is to provide compensation. So that's the other thing that we need to put in the right perspective. Sorry. I'm just getting at some notes here that I made. Okay, so in terms of misconceptions, that's probably the most of them. That's probably the bulk of it. The biggest ones that we need to, or that always comes up, is that one, the first one mentioned, which is that just because the doctor screwed up, that means people think that means the doctor has to pay, and it's just wrong.
Yeah.
So.
Yeah. Lawyers that are considering establishing a practice focused on medical malpractice.
Sorry, say that again.
What are some lawyers that are considering establishing a practice focused on the medical malpractice world? What are some key factors they should consider? We've spoken about a few, but
yeah, I have spoken about a few. I mean, you need to work with somebody else for a period of time in order to, figure out how to do this job. But the other things are, if you're going to do it, got to make sure that you've got the financial resources behind you to be able to do it properly. You need to immerse yourself in the medicine. That's a big deal. You need to understand the medicine. And it's not just picking up a medical text and reading, for example, about fetal heart strips and how to read a fetal heart strip. You need to understand all of the nuances associated with reading a fetal heart strip. And when, when initially it doesn't look good, how can it change? And then it's okay again. And then even if it's okay, how does it get bad again? And blah, blah, blah. All the subtle little things. And that's a function of experience. And, it comes back to working with other people in order to make sure that you know the job. But it's the three big things are know the medicine, know the law, have the finances to be able to fund the cases. Because if you don't, you're going to get buried. It's as simple as that.
It sounds to me that medical malpractice lawyer is basically somewhat of a doctor as well, because of how much they need to learn.
Well, I have had people. I constantly have people asking me medical questions, and I have had people asking me whether or not I will attend the birth of their child with them, and the answer is no. Very last thing the doctor wants is their lawyer sitting in the room watching them do the job. But
yeah, no kidding.
But
how do you see the intersection of law and technology evolving in the context of medical malpractice litigation?
Well, I mean, if we're talking about AI and that sort of thing, I mean, it can make some parts of the job easier. It can make, the compilation of records easier. It can make the summary of what's in the records easier. It can help do some of the basic medical and legal research a little bit easier. But as things stand right now, first of all, it's unreliable. And so you have to be super careful that anything it tells you is actually correct.
Mm-hmm.
And the other thing is that we're still at a stage where the analysis and in particular the judgment of the lawyer who's doing the work is the critical factor, and AI has no concept on that.
Yeah.
I mean, we're a long way away from AI being able to duplicate the judgment of a lawyer who's been doing this kind of work for a period of time.
Have you leveraged any of these systems or processes for yourself?
Some, but
Some.
as I said, it's limited to what we can do, because I'm a little hesitant to rely on the summaries that they give us, either of the law or the medicine, because of there have been horror stories where lawyers have submitted briefs that they've generated through AI, and they've just been wrong. And not only are they wrong, but the AI just made up the cases that they relied upon, and the lawyers have been disciplined for trying to rely on non-existent cases, that kind of stuff.
Jeez.
Yeah, and in terms of the medicine, there are similar problems. So we need to be very careful about that. But we certainly do use the internet. We use online access to medical records, medical reports, medical journals, etc. But in terms of having AI generate a lot of stuff for us, we're still at the stage, because it is so unreliable. We are at the stage where we still do that mostly ourselves.
And that makes sense. What trends do you see shaping the future of medical malpractice litigation?
Well, I see it only getting more difficult, honestly, as
Yeah.
the medicine continues to develop. A lot of the developments in the medicine, and I say this in part because I go to medical conferences all the time, and a lot of them are focused on, they don't say this explicitly, but a lot of them are focused on how do we structure things in order to keep our practices out of the courtrooms. And it's not, half the time it's not by doing better medicine. It's on, how do we structure the guidelines in order to make sure that we've got enough wiggle room that we can work our way through. But in any event, I see that it's going to get more difficult in terms of the standards and the guidelines that are produced by the medical community. That's going to be more difficult. It's going to be more difficult in terms of the causation issues, all the things that are going to make it more difficult for us to prove that the injury is the result of the negligence of the doctors or the nurses or the midwives or whatever. And in terms of the development of the law, there's always a pendulum that operates in the law. Right now, we're in pretty good shape in terms of the courts seem to be listening to some of the things that we're saying about the need for compensation for a lot of our clients. Mm-hmm. But there is an inevitable swing back from time to time, and we just have to work our way through those swings. You have to recognize them when they're coming and do what you can to deal with them. But it's really the changes in the medicine that are going to change. They're going to make our practice more difficult, make our practices more challenging, and quite frankly, make them more interesting. It's the fun part of the job, is figuring out how can we construct bulletproof cases based on the medicine as it exists, even as it's evolving.
That's a great answer. Finally, last question. What legacy do you hope to leave behind in the medical malpractice litigation world?
I thought about that question, and I thought, one of the things that surprised me, I got to tell you, when I started practicing, was there were a number of lawyers that I knew that were really preeminent lawyers, really considered the very top of their game. Everybody thought, man, this person is just as good as he or she gets. And as soon as they retired, they just basically disappeared. I mean, nobody talked about them anymore. It was like they never existed. So I'm not anticipating on a personal level that there's going to be a real legacy in terms of wow, Paul McGivern was really a great guy. But I am hopeful, and quite frankly, I expect that the people that I work with, my partners, Suzanne Rabb and Lindsay McGivern, and the other lawyers that I work with, Kate McInnes, Jessica Kim, that as a group, they're going to continue to make this firm one of the foundational firms for really high quality medical malpractice work. And that, to me, more than anything else, is the legacy that I want to see and the legacy that I expect.
Awesome. Well, great answer, and I look forward to seeing that happen.
Yeah, me too.
Awesome. Yes. So to our listeners, Paul's information is going to be linked below. Feel free to check him out on LinkedIn if you have questions. If you're a lawyer, I'm sure he'll love to talk to you and, maybe take on some mentorship himself. And Paul, thank you so much for your time today. I really appreciate it.
Thanks for the invitation. It was a lot of fun.
Awesome. All right. Thank you.
Okay. Thank you.